All right, thank you, everyone. Welcome. I'm Ed Martin, the president of the Phyllis Schlafly Eagle Forum Educational Legal Defense Fund. We're so proud to be here. John Schlafly is with me on behalf of our board of directors, our staff. You may see Ryan Haidt around. He's worked really hard to keep everything going and on track. So thank you for being here. And let me say thank you more for building such a community now. It's a number of years in a row after we got through the COVID stuff. Tom Massey will make editorial comments later. Thomas, thank you. No, he won't. I'm just kidding. But you might if it was the COVID stuff. But we just have such a community, you know, and there's a sense. I remember the first one of these that I came to a few years ago in this space, which I'm glad we're back here. We ended up down in the very basement at the bar, and I remember saying to, I think it was to John or maybe Jim, like all these guys and gals, there was a couple of couples there, they'd invented stuff and they were business people and they were in the fray. It's just such an interesting and important group that's developed that has such an important mission at its heart. And on Phyllis Schlafly's behalf, we gather and we're just so honored. So thank you. This afternoon, I hope you were there. We did record it. We'll have that available too. The panel discussion there covered a lot of ground, but also had a lot of expertise. Had a number of questions and had a few answers, not all the answers, but a lot happening. And so we're really, we're grateful. You know, the topic for our afternoon session and the phrase we're using today is talking about patent infringement. And, you know, I heard someone say earlier, had a question. Was it Gene? Did you say something about New Jersey? Yeah, it was you, New Jersey. So in New Jersey, they call patent infringement theft. Yeah, theft, you know, just steal stuff, yeah. So, and we believe that also, and especially believe in naming names on what's happening. Sometimes that includes members of the Republican Party in addition to the Democrat Party, and we're committed to that. So on behalf of the large and small innovators, the big and small business people who are in this, but that want to honor patents, it's important for us to be together. So we'll have that up on video. In just a few moments, we'll have the great honor, privilege of hearing from former judge of the Federal Circuit Court of Appeals, Kathleen O'Malley. We're just so grateful that she is here and agreed to spend some time. Over the last few days, we were back and forth, a number of us, as she was preparing for this and taking her responsibility, her message tonight so seriously, which you'd expect. And we're just grateful. The topic that she'll talk about is the state of patent infringement. Before we do that, I'd like to ask Stephen Rogers to come up. You all know him as an inventor and a business leader, someone who's been so clear on this. He's going to lead us in an invocation as we start. So please, if you would, Stephen.
Thank you very much. Let's bow our heads. Dear Heavenly Father, we have so much to thank you for our lives, our friends, families, for this opportunity to work, for our trades, so much to thank you for our country. We pray that you would bless our efforts, that you would give us success in them, and that you would allow us to do what is right. And we thank you especially for being the original inventor. For inventing us. Thank you for this food and for this time together. In Jesus' name, amen.
Thank you, Stephen, for your leadership in so many ways and for a spectacular prayer to begin. Thank you. One of the best things to be in life is related to Phyllis Schlafly. And that's why John Schlafly is here. He's been living off that for, no, anyway, and we'll hear from him later. And the other way is to marry into the family. And so Jonathan Pullman is going to come up and lead us in the Pledge of Allegiance. He married John's younger brother Bruce's daughter. And Jonathan Pullman is an attorney who practices at Stinson law firm out in Missouri and has come every year now for 3 or 4 years faithfully recruiting some of his colleagues and looking for work. So we're grateful that he joins us and very appreciative of the incredible Schlafly family and all that they've done for so many of us. So Jonathan, to lead us in the pledge. Where is he? There he is.
Thanks for joining me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And I should say, Jonathan did announce to us that he had his wife did the heavy lifting about 5-6 weeks ago and had their fourth child, Clara. And Uncle John is going to make a substantial gift. That's great, John. Thanks for doing that. All right, so we have some special guests that we want to thank. First of all, every year we have sponsors that step up that are willing to do this. We're grateful for that. I want to say thank you to Jim Edwards for leading us in that. We'll hear more from Jim. Acacia has been there every year for the last few years, especially the Acacia Research Group, the Biotechnology Innovation Organization, and we appreciate them very much also. Thank you. The Innovation Alliance also been so loyal and so helpful, and InterDigital, and others of you here probably want to be sponsors. It's no problem. Talk to Jim. We'll add you very quickly. But thank you to those sponsors. Special guests, there was a bit of a mutual love society happening. Congressman Thomas Massey said Congressman Posey is a great American, a race car driver, all sorts of other things. And then Congressman Posey said, we love our Thomas Massey. And so Thomas Massey is here. He's been with us, I think, almost every year. He's received all of our awards. He's been fearless, and he is now famous as the inventor of the Klux capacitor. Thomas Massey, please. Thank you for being here, Thomas. Oh, and the debt clock, the pocket debt clock. Yeah, let me show you. This is important. He's not monetizing the debt. That he would never monetize the debt. It's not going over as well. That's a congressional dad joke. But you can go to debtbadge.com and get your own version of this. It's not. He doesn't profit from that, but you can get one. And thank you for this gift, Thomas. It's very, very kind. Congressman Bill Posey is here with his lovely wife, and we'll be hearing from him later. Thank you, Congressman, for taking the time to be with us and for your leadership in so many ways. Judge Kathleen O'Malley, I mentioned earlier, a retired judge of the Federal Circuit. She's over here. Thank you, Judge. We appreciate it. Brian Dorini, Director and Senior Standards Counsel at InterDigital. Where is that? There you go, Brian. Thank you. Where are my glasses? Okay. And Professor Adam Mossoff, where is Professore? He's got great, thank you. He's got tenure. He's been telling me about it. Gene Quinn, President and CEO of IPWatchdog. We'll also hear from him later. Stephen Rogers, again, thank you, Stephen, for being with us. And he's the founder and chief executive officer of Centripetal Networks. And Hank Sauer, our great friend Hank Sauer, who's been so good to us. Hans. Sorry, Hans. I promoted you there. I didn't know what that was. Sorry. Hans Sauer, Deputy General Counsel and Vice President for Intellectual Property at Bio. And then, of course, Laurie Self, who has been in our life and in our work for so long. She's the Senior Vice President and Counsel of Government Affairs at Qualcomm. Senate and House staff, I saw some of the folks over here. If you'd stand, if you're Senate or House staff, that would be great. If you don't want to stand, put your hand up. But that's great. Thank you all for being here. Yep. Thank you. We know that you guys do all the work and, don't get any of the glory. So, Judge O'Malley, you're up first, and we're so grateful, Judge, if you'd come up now. Judge Kathleen O'Malley, formerly a judge on the Federal Circuit Court of Appeals. Her 27 years on the bench began in 1994 as a district judge in the Northern District of Ohio. In 2010, Judge O'Malley was elevated to the Federal Circuit. Judge O'Malley is the only former district court judge appointed to the Federal Circuit. She began her legal career as a litigator in complex cases. Since leaving the judiciary in 2022, Judge O'Malley is of counsel with the law firm Irell & Manella. She serves as a senior advisor to the Renewing American Innovation Project at the Center for Strategic and International Studies, and she's on the board of the Council for Innovation Promotion. Judge O'Malley also represents the United States on the World Intellectual Property Organization's Judicial Advisory Council. She's busier, it sounds like, in retirement than before. So, Judge O'Malley, thank you so much for being with us, and you're going to speak on the state of patent infringement. Thank you.
All right, the state of patent infringement is awful, okay? Go on to eat. No, it's funny because I did write up a speech, and it was based on things that I've been saying for years and years. And then as we were preparing for this, I asked about Phyllis Schlafly. I should have known more. I did know some more, but I didn't know anything about her views on patents. And so I was offered some information about her views on patents. And I started reading them, and it was almost like she's my intellectual doppelganger when it comes to patents. There were things in her speeches that were word for word out of speeches that I've been giving since about 2012. And then I thought, well, I wish I had seen these earlier. I wouldn't have had to write all of that stuff. She did all the research for me. But it is fascinating to see what her view of patents is and their role as private property rights, and how important it is not to lose sight of the importance of patents. You know, I have been on the bench since 1994. I am a double Democratic appointee, and I'm probably as aggressive on the property rights side about patent issues as anyone in this room. I do not understand losing sight of that issue. And a lot of what I'm going to say also was said this morning, so I guess between Phyllis and them, I could probably throw this away, but I'm going to give at least a few highlights from it, including what I think needs to be done immediately. This is really important. This is an important issue to me. I think our patent system has fallen completely out of whack, completely out of balance. It is true, and I'm going to give a little more deference to Madison, since I didn't hear much about him this afternoon. It was all about other founding fathers, but it's Madison that was the heart of the patent system. He was the one who envisioned a patent system that was a democratic patent system that differentiated us from England, so that you didn't have to have money, you didn't have to be able to practice your patent, you just had to have a good idea. And the idea was, anybody with a good idea should be able to get a patent, and actually should be able to make a livelihood out of those patents. So believe it or not, our founding fathers created patent trolls. They didn't call them that, but they created non-practicing entities, not as a mistake, but on purpose, because they wanted farmers and tradesmen to be able to have a good idea, to invent, to get a patent, and then to license those patents. I mean, some of our best investors, as you heard earlier today, inventors, didn't practice their patents at all. Goodyear didn't practice any patents. I mean, Edison didn't practice any patents. I mean, it's unbelievable. They all just licensed them. Today, we would call them patent trolls. And that's part of our problem. We have let the dialogue become fake. Well, we've let fake dialogue become the reality. And we have to reverse that. I mean, if you look back at our history, every time we've had a strong patent system, and that includes a balanced patent system, you know, there was a weird period of time where we were worried in history that we weren't granting enough patents, so we just took away all examination requirements, and then we had this flood of really bad patents, and people were just copying each other's patents, and anybody who paid a fee could get a patent. So obviously, a lot of bad patents is not a good idea. So then we reframed it. In the beginning, we didn't have enough patents because we left, you know, 3 of the heads of state to be the ones deciding who gets patents, and they didn't have any time. So then we went to too many patents. So I don't mean to sound Goldilocks, but really the point is to have a strong patent system where we have strong examination of patents, and then once you get those patents and you build a business on those patents, that you should then have the right to maintain those patents and to practice those patents. And what we've done is ignore everything about that. We've ignored the fact that people do build their businesses based on the fact that the government said, yes, this is a great idea, and you deserve a patent for it. The government's not going to always get it right, but I would say that we ought to presumption of validity, we ought to presume that in most instances they get it right. And we shouldn't make it so hard to maintain your patent and to fight for your business that was built on that patent. What we have done now is almost assume that patent rights are there to be taken away. So the first, of course, we talked about this at length today, the eBay decision was horrific. I know a lot of people were questioning why it was so horrific, but I can tell you that when I go around the world, and I do a lot of international work, I go around the world and the judges from all over the world say, it was the eBay decision that started your slide from preeminence. We were the most respected patent system in the world 20 years ago. And now we are way down the totem pole. China's system for protecting patent rights is much better than ours. And as you can imagine, theirs, Germany, other countries, they're going to take over the preeminence. And they're trying. And they don't think it's going to be very hard because we keep giving it away. So first is eBay. Next, we passed the AIA. I'm sure that it was well-intentioned, and it was certainly driven by this patent troll narrative, so that where everybody said that anybody who doesn't practice their patents is a bad guy, that instead of being something that the Founding Fathers expressly wanted, it is something that we should dislike. And it is true that there were some bad actors. There were people buying up and trying to enforce patents that probably should have never been issued in the first place. But that was really a straw man that was put up. There have been lots of studies that have shown that those patents, those bad patents, are not primarily being enforced. And there are lots of ways that the courts could address those questions. But we passed the AIA when I had just shifted to the Federal Circuit when the AIA passed. And I remember looking at the AIA thinking, yeah, there were a lot of things in here that made sense. And they talked about strengthening patents so that good patents could be amended to get stronger, and really, really, really weak patents, the low-hanging fruit, would be gone. And it seemed to make some sense. Then I get on the court and I realized that the way the patent system, that AIA was being implemented, was completely the opposite. It was a way to go after good patents and to do away with patents altogether. It was horrible. And not only did the Patent Office implement it improperly with using the wrong claim construction, with using preponderance of the evidence, with allowing the Federal Circuit to review decisions of the PTAB under the Administrative Procedures Act, not having a standing requirement, all of those things allowed the PTO to run with this system. And remember, they make a lot of money in validating patents. So they charge all these patent owners to keep their patents alive, and then they make a lot of money in validating them. There are so many things about the AIA that I got upset about that's when I started saying, wait, there's something wrong here. And certainly Congress could not have intended all this. And then I write a lot, in my opinion, some of which landed some of these issues in the Supreme Court. And then the Supreme Court said, oh yeah, that's all Congress wanted. Congress really wanted to just do away with patents. That was the whole purpose of the AIA. And, so it was not sold that way, but that is the way it has turned out. And as we talked about earlier today, there has to be a fix. Whether it's a complete repealing of the AIA, I don't see that happening in any real world, or it's some tweaks that we could fix it. There are lots of things we could fix. And my shock is that the Supreme Court did not see that even when the PTAB was completely violating the statute that Congress had written, that the Supreme Court said that's okay because it's still fulfilling the purpose of getting rid of patents. So I think there are a lot of things that can be done. You can see there are pages and pages here that I have not talked about. These are all about the importance of the patent system, but we've heard so much about that already that I think we just need to recognize that we are going to lose dominance. I mean, we are going to lose dominance in our economic standing. We are going to lose dominance in our healthcare standing. Right now, 90% of innovation comes from the U.S. And more than 90% of new drugs and new healthcare developments come from the U.S. But we're going to lose all that in the long run if we don't protect the patent system. It is the engine of innovation, and not just innovation, it is the engine for our security, our national security. It's really important, not just for our economic standing in the world, but for making sure that we can fight and have the technology we need to protect ourselves from nations that don't have the same principles that we do. And so it is very important, and especially in our market economy, because we don't have the ability to have the government hand us everything. Yes, we have government research, but even there, we've got the issue of having to partner with the private partners. We need to incentivize the private investors. So it's not just about inventors, it's about investors as well. Where are they going to invest their money? Are they going to invest their money in things that are protected by patents? Yes, but not if they think those patents aren't going to last, or if they invest all that money and it disappears very soon. So I think there are some important things that we can do. I'm sorry, this is hysterical. I've got so much in here that I was going to say, but so much of it has been said that I'm trying to protect you from hearing it again. I believe that Congress is to blame for the AIA. I believe that the Supreme Court is to blame for 101 jurisprudence, for eBay, for oil states. There are many, many cases in which the Supreme Court has not only evidenced antipathy toward the patent system, but has come right out and said it. I mean, as we talked about Justice Kennedy, he actually mentioned the whole troll dialogue in his concurrence. What did he know about it? He didn't know anything about it. He just saw posters about it. He just heard things on social media. He has young law clerks who are telling him what is being said in the world and not actually investigating whether anything that's being said is true. So I blame a lot of people. And of course, the Federal Circuit deserves some of it, but frankly, I don't think as much as most people think. I don't think the Federal Circuit deserves blame in the 101 space. They've tried to fix it many times and begged for the Supreme Court to fix it, and it refuses to. So I think we have to make sure that investors don't look more and more overseas, because that has severe, as I said, geopolitical implications, and not just economic ones. With our economic strength comes our freedoms. I mean, the reason the founding fathers thought it was good to have a patent system that could buoy our then nascent economy was because they felt that that was the way we could remain free, and that we could then have all of our other, all the other things that the founders believed were important concepts that drove our country, that we could protect ourselves from other countries who don't have those same values. So I am going to suggest a few things. You can imagine what some of them are going to be. I think we need to make sure that we protect patents as property rights, true property rights, and that we recognize that the Constitution says there's the right to exclude. I mean, you can't have an exclusive right without the right to exclude. I know you've heard this many times, but it's true. And so I think the first thing that we need to do is we need to do an eBay fix. And it's not hard. We did it with trademark law. How is it that like 10 minutes after the eBay decision came out, Congress passed a bill saying there's a presumptive right to injunctions in trademark? Why are trademark owners, who frankly are mostly, don't get me wrong, I do trademark work too, but why are trademark owners who are protecting mostly consumer goods, why are they more important to our economy than patent owners? That it baffles me. So we could get an eBay fix, and I think it would be easy. I think it would be very easy. I think we need to actually say that patents are property rights, not quasi-property rights as the Supreme Court tried to say in oil states. You notice that Justice Gorsuch tried to pull back from that and say that's not really the case when he wrote SAS, but nobody was really buying that. So now they're still of the view that they're not really property rights. They're property rights granted by Congress. Granted by the government. Of course they are. But they're not monopolies. Everybody tries to say, oh, that's a monopoly. We don't like monopolies. Patents are not monopolies. Patents are granted for limited periods of time, for limited sets of rights, in return for the trade-off of giving the world your invention and disclosing it to the public. Patents are very limited property rights, I get that, but they're truly property rights while they're owned, and they should be treated that way. So I think that Congress can declare that patents are property rights, and they can do that in conjunction with the eBay fix, that because they're property rights, there is a presumptive right to an injunction. I also think that there are many eBay fixes. I can't go as far as to say that we should do away with it because I just know that'll never work. But we could do a lot. We could now say that when it was originally implemented, they said you have to use the broadest reasonable construction. And then Andrei Iancu came in, who I'm not just mentioning him because I work with him now, but Andrei Iancu came in and changed it and said, no, we're going to use the actual construction of the term. We should put that in stone because that way we can avoid the next director coming in and saying the opposite. There is right in the statute says that that the burden of proof is by just a mere preponderance of the evidence. These are property rights. It should be by clear and convincing evidence, just like it is in court. That needs to be changed. It absolutely needs to be changed. They could also declare that the standard of review by the Federal Circuit is not under the Administrative Procedures Act. I mean, the Patent Office doesn't like acting like an administrative agency in any other context, but they love that because they get such a deferential standard of review. So if a district court says that a patent is valid and infringed, the Federal Circuit has much more freedom to overturn that. If the Patent Office says, oh no, we're gonna invalidate this patent, the Federal Circuit has very little flexibility to do anything with that. These are all things that could happen, and I don't think they're so huge that you have to say, I am doing away with the AIA. There's some things in the AIA that make sense. The other thing they could do is put in a standing requirement. Right now, anybody under the sun, and there are stories, horror stories, of an organization that happened to be built offshore called Orange, shockingly, challenged a patent that Apple was being sued on. Those kinds of things should not be allowed to happen. And so a standing requirement means that only those with a real interest. And I don't just say this for the pharma people in the room, if something is subject to a Hatch-Waxman proceeding or a Biosimilars Act proceeding, which means they're already on a fast track, they've already had a shortened lifespan, there's no reason that they should be allowed to be challenged in an IPR. It's two different statutes fighting head to head. And I don't know why anyone didn't notice that when the AIA was being passed. So these are the kinds of, I think, discrete changes that we could do to fix the patent system, to fix the AIA, and to bring back Phyllis Schlafly's vision of patents as true property rights that we need to protect. Thank you.
Thank you, Judge. Thank you for that and for the time and for being with us. And also thank you for mentioning Director Iancu, who has been with us in previous years and whom we appreciate so much. Gene Quinn, time to come up, and the rest of the panelists. We've got a lightning roundtable. Patent infringement's effect on innovation and commercialization. Gene's going to moderate. Brian Dorini, Hans, see Hans, not Hank, Hans, sorry Hans, and Laurie Self. Come on up here. The Phil Donahue setup is going to be great. Everybody knows Gene, but I'll mention he's the founder and CEO of IPWatchdog. He is also a patent attorney, obviously, and is one of the leading commentators. People seek out his counsel and his insight, and we're grateful for his leadership. So, Gene, take it away.
Great. Thanks a lot, Ed. So we're going to do this in lightning round kind of fashion. I've got some notes. We had a call, and the first thing that I want to do is just very briefly reintroduce Hank here. Good to meet you. Hans Sauer is Deputy General Counsel of the VP for IP at the Bioindustry Organization. Laurie Self is Senior Vice President and Counsel for Government Affairs at Qualcomm, and Brian Dorini is Senior Standards Counsel at InterDigital. And what we have tried to do is agree to go very fast so we can get as much coverage as we can. And the first thing is I'm going to give each one of them 1 minute, if we can, to give your initial thoughts on the consequences of patent infringement and what it means from your vantage point. Laurie, let's start with you. Oh, well, we could start with somebody else. Yeah. Hans is saying under his breath, no, let Laurie start.
first of all, it's okay. That's on. Good. The consequences of patent infringement. I mean, I think.
What does it mean for Qualcomm?
So Qualcomm is the world's leading developer of wireless cellular communications technologies. This is an incredibly complex area of technology, about 10 years of advanced R&D that precedes any commercialization of those technologies. And then once they are commercialized through standards, they become ubiquitous. There is no device, mobile device in the world manufactured that does not use our patents. So patent infringement becomes, particularly patent infringement without meaningful remedies, without meaningful recourse, becomes an incredibly destabilizing impact on our ability to invest in that high dollar, high risk R&D.
Great, thank you, Laurie. Brian, from InterDigital's perspective, what does patent infringement mean for you?
Yeah, thanks, Gene. And just really quickly, for those that might not know InterDigital, R&D-based company, U.S.-based, up the road in Wilmington, about 400 employees, half of them are engineers. Patents are our lifeblood, and patent licensing is our primary source of revenue. So infringement that does not have a license associated with it, so we'll just call it holdout, because that's how it usually manifests itself, it's tantamount to a massive transfer of two things. R&D innovation from U.S.-based company like InterDigital to the holdout companies that aren't paying for the use of the technology, and those historically and typically have been Chinese manufacturing companies. And it's also a massive transfer of leadership in standard development organizations. And that is a transfer from companies U.S.-based like InterDigital to the holdout companies who have all the resources still in their pocket, typically Chinese manufacturers.
I find it interesting that we use hold up and hold out the way that we do, because it feels to me like the companies that ignore your patents come in and basically hold you up, like in the Old West, with masks on, and just take what they want. And that's unfortunate. Hans, you represent a whole bunch of companies as their public policy voice here in D.C. No pressure I'm putting on you, but in the entire weight of the industry, really, quite frequently, is on your shoulders. It feels like you're swimming upstream. What does a patent infringement mean for you and your companies?
I think the answer will become clear when you think about a few things that are pretty central to our business model. So BIO is the Bioindustries Trade Association here in Washington, D.C. We have about 1,000 members, mostly in the therapeutic and biomedical space, also agricultural companies. It's a diverse industry, but the way patents work for our companies tends to be pretty uniform. Right? So think about long product development times. It takes over a decade to bring a biotech product, whether it's a drug or an agricultural, like a modern seed product, to market. More than 10 years. High risk of development failure. Chances that a developmental product will never come to market are close to 90%. Right? So when you start investing, you have approximately a 10% chance of getting to market. We have a high need for partnering and technology transfer between companies or from the public to the private sector. We need patents for collaboration and for the orderly dissemination of technology, and most of all, we need patents for access to capital. Historically, that's worked well. Judge O'Malley said it earlier, the United States originates more new treatments and new therapies than the rest of the world combined. Innovation-wise, I think historically we've had a good track record. Absent patents, however, that model will break down and we won't be able to mobilize the resources of the private sector to fund all that innovation. And I don't know if the public sector is going to be available to pick up the slack, but maybe that gives you an idea of why we pay so much attention to patents.
Okay, great, thanks. And just to let you know, you all went over, but that's okay. No, so I'm just joking. I'm just giving you a hard time. We can laugh. We can have fun, right? So, Hans, let's start with you in the next phase. One of the things that during our pre-call you had said that you wanted to specifically address briefly was how government is abandoning its long-held beliefs in IP. Do you remember that?
Yeah, I remember that. I'm being reminded of it every day. Right, so historically, it's been said before tonight, the United States government and policymakers actually have adhered to decades-long, well-held beliefs and policy positions that encourage robust intellectual property rights, not just in the United States, but globally as a gold standard. I think it's driven by a belief that the U.S. innovation system is globally very both competitive and very successful, deserves to be emulated, and also that U.S.-owned intellectual property in the countries of our major trading partners deserves to be protected just as much as we protect the intellectual property that's owned by our trading partners in the United States. Right? There's a reciprocity question here that's always been pretty central to U.S. positions, and we've always advocated for gold high standards. That is clearly changing on so many levels. It's one of the trends that I observe in June of last year in a world awash with COVID vaccines at the time. The U.S. government agreed to a global waiver of intellectual property, especially patents for COVID vaccines. And that was mainly targeted at a few US manufacturers. We're not aware, really, that in the world at the time, there were over 30 COVID vaccines that were in human use. Right? All the debates in Geneva and elsewhere only centered on the ones that were made by American vaccine makers. Right? And a narrative was built up that the world can't be saved unless the IP of 2 American companies would be broken. Right? And hence, we need an IP waiver, and the U.S. administration was willing to go along with that. I think one, and then I'll stop. I think one thing to keep in mind is that patents, not just on vaccines, but generally, are important enough to our competitors to demand asymmetrical trade concessions from the U.S. government, and they are apparently unimportant enough to the U.S. government to trade them away for other trade benefits. And whether we get a good deal or not, that's neither here nor there, but we need to be aware of this. Right? This administration does not deem patents important enough to not trade them away for something else.
I'll just make a quick comment there. If you had any doubt that this was really about an IP grab, all you had to do is look at the timeline. The IP waiver issue didn't come up until, by any fair estimation, the pandemic was over, or we were in the final quarter where people were getting sick, but not necessarily going to the hospital. And certainly, by and large, most of them were not dying. And we knew that the following flu season, it would be gone, just like every coronavirus gets weaker. But they still, in the face of that scientific reality, saw the only option as busting intellectual property. This was never about the COVID issue, never about public health. It was about grabbing your patents by any means necessary. I'm just to make sure everybody gets an opportunity to get your thoughts out. I'm gonna go, and if we have any time left over, then we'll go around and get your comments. Brian, next, you had mentioned during our pre-call that lost innovation, holdout, lost opportunity to exclude is a big issue because people don't understand that this really costs money. So can you elaborate on those thoughts for us?
Yeah, sure. And then maybe I'll throw in a bonus if I keep it super short. And this comment has been mentioned certainly by Laurie and maybe by Hans as well. I mean, the development life cycle is long. We're not even in pharma. We're just in video tech, cellular, wireless. But it takes years to develop this technology, to get it patented around the world, and then you've got to start your licensing program. And the companies are still holding out. I mean, you can be 10, 12, 15 years into your patent, staring at 5 more years without having gotten a dime back. And for a company like InterDigital, who does routinely plow 20% of our revenues back into R&D, when the licensing is your revenue stream, it really curtails what you can do. So that's a huge factor. One thing I'll just tack on is it's hard to have a conversation about holdout without talking about injunctions. It's been mentioned many, many, many times, but it's very clear from InterDigital's perspective that if you can't stop somebody from using your patents, there's very little incentive for them to come to the table. And I don't know if I have any more time.
Yeah, if you want to go into your bonus.
My bonus. One of the other great solutions, I think, and it'll be great to get some comments during dinner about this, to trying to prevent infringement would be to provide some sort of sense of quiet title to a patent. And there actually are some ideas going around there. Some of the PTAB reform I've seen would sort of touch on providing, some conditions when you can no longer keep attacking that government grant of a patent. You cannot keep asking for a redo. There's only so many bites at the apple you can take before a company is entitled, and I'm looking at Centripetal now, to rely on their investment. It's very critical to do. And it's not some novel moonshot idea. I mean, the sense of having a quiet title is in a variety of different areas of law. I'm sure there's here that can speak better to it. Of course, quiet title comes from real property. There's the concept of double jeopardy, of statute of limitations, of contract reliance. I mean, there's a lot of different themes that I think you could draw on to provide some stop to it. It does remind me, too, to give credit where credit is due. I know Dave Kapos and Paul Michel have been talking about a gold-plated patent, which would provide a little more protection. I'd love to see it go further, but that's the idea.
Yeah, I think there's a lot of little things that we can do. Not that I don't want to get rid of the PTAB, Congressman, like your bill would do, because I think that would be wonderful. But I think the rest of us need to be pushing it on different angles, as Congressman Massey is forwarding his bill, and see what we can do that makes it better a little bit along the way. And if it can go away, it can go away. But one thing along that idea is, why can't we change 261 and get rid of the word private and add the word real, and make patents have attributes of real property and tie it to all those 1,800 cases from the Supreme Court where patents really were treated like land. I mean, little things like that. And I encourage all of you to think about those little things, like Judge O'Malley did, because we can make this better in ways that they can't really argue against us if they're honest. And we just have to hold them to that. Laurie, we thought maybe you might, you can talk about whatever it is that you want to talk about. But I understand that you have a nice way of explaining the U.S.-China issue and what that means, and
Sure.
I mean, what does it mean for Qualcomm that really you have probably a stronger patent system in China in some ways than you do in the U.S.?
Yeah, although I will comment that if you think about what the U.S. patent system backed by a independent judiciary and a strong rule of law, at least historically, what that has enabled versus what we see in China, and again, obviously not an independent judiciary, and you have a judicial system that's really heavily susceptible to political pressure and really designed to support their own national champions. I think that is a fundamental difference we all have to keep in mind. But just a couple of comments, Gene, to your question. First of all, just to echo what Brian said, the role of the injunction is to create incentives that bring often bigger players to a negotiating table. That is the historical function of the injunction. And in a market-based economy, a patent system that is designed to promote specialization, where smaller players can succeed through invention, that incentive structure is deeply important. And it's even important for large companies like ours. I mean, we were brought to our knees because a group of very powerful players refused to pay for our technology. And again, just the incredible destabilizing impact that has on the revenues that support R&D. When we talk about R&D, we're talking about human beings, by the way. We're talking about the world's best engineers who are highly paid, highly specialized, and the question for a company like ours or any inventive entity is, can you sustain that workforce? If you don't have the revenues to pay those individuals, you lose them, and of course you risk losing the company as well. But I think the U.S.-China dynamic is a fascinating study in cognitive dissonance. On the one hand, the entire government is now laser focused on a geopolitical, geostrategic race with China that is really center focused on technology leadership. Which country will lead the world in cutting edge technologies that are inextricably tied to national security interests, semiconductor, AI, quantum, biotech, you name it. But what we find incredibly frustrating is that, for many of the administration and even congressional stakeholders that are driving those policy discussions, there is little, if any, understanding of the fact that you cannot, as a U.S. market-based innovation leader, you cannot sustain that technology leadership position if you do not have a strong patent system. There is no plan B in this country that will fund the billions and billions and billions of dollars that are invested by the private sector in, again, long horizon, high risk innovation. If you undercut our patent system left and right, whether it's through remedies or PTAB or what have you, you are fundamentally attacking the ability of U.S. allied companies to lead in these critically important technological sectors. And I would not advocate for a plan B. I mean, this country is not good at, as Brian put it earlier, command and control innovation. The genius of our intellectual property clause, the genius of our founders was recognizing that a democratized approach to innovation is the approach that enables the greatest number of people through their own ingenuity, self-interest, what have you, to make investments in innovation and to allow the market to dictate which of those innovations are most valuable, most important. That is why we lead the world in innovation and why we have since, Adam will correct me on the exact date, but let's say the early 1800s. In contrast, we are competing with also innovative Chinese companies that do benefit from a kind of top-down subsidization model. Now, we feel strongly that, again, if we sustain a strong patent system, we can win those innovation races, but it really is premised on the fundamental strength of our patent system. So that is the conundrum we find ourselves in, where one arm of the government is laser focused on winning these technology races, where the other arm is constantly hamstringing us with these policies that are antithetical to that success.
Yeah, and one thing that came to mind when you were saying what you were saying, government has gotten very good, particularly state governments, and to some extent federal government, at telling us, by this date, you're going to do the following, innovators. By 2030, you're going to have half your cars are going to be electric. By 2050, 100% of your cars are going to be electric. That's not what Kennedy did with sending a man to the moon. He challenged us. And in Lincoln's view of the patent system was to spur the creative genius with incentive. You want to incentivize, you want to challenge. You can't say with innovation, because we never know when that breakthrough is going to come. But if we stop looking, you know what? The breakthrough is never going to come. And that's the real risk. So we're doing pretty good on time. I assume we still had 25 minutes from when we started. Can we go through a rapid fire? Okay, so let's do rapid fire. Your final thoughts. Now, hopefully there'll be people who remember more than one thing from today. But if there's only one thing that they can remember from today, Hans, what do you want that to be? And you two got off easy because I started with Hans, but you're going to get the same question. One thing that they need to remember on the way out tonight.
Be careful about false narratives that seem to make sense, but that are faulty. We see it on every level. We see it either, to policymakers. We see it in the courts. Just this one observation, because we have members of the judiciary here. We see more and more, I think, courts, and that's especially true for the Supreme Court. I think we just saw it in their most recent patent decision. They are frustrated and uncomfortable with technically complicated, commercially complicated disputes. They are presented with appeals that are actually teed up on narratives, where the court, when the case reaches them, is being told, you know what, you don't need to understand everything that went on in this case. It's
well, that's
simple.
good, because they didn't.
Yeah, and they didn't, right? But what they do is they revert to simple narratives that they decide. And in the end, the decision, whatever it is they're deciding, no longer is a dispute between two parties. It's an artifact.
Well, that particular decision you're
Very scary.
referring to could have been written without any reference to the facts, and in fact was written without any reference to the facts.
Very much. Yeah.
You know, and that's the scary thing. They wrote that before they even heard the case, and certainly they didn't read the record, because the record contradicts what they said. Brian, your one final thought.
One final. Well, earlier I mentioned that infringement is a transfer. Innovation and transfer of leadership at SDOs, and that's the one I just want to tee it up and make it clear that we all remember there's a winner and a loser. The loser, of course, is easy to focus on, but there's a winner. Someone else is benefiting from all of this infringement that's not getting paid for. In our example, it's the companies that aren't paying us. There may be other examples, but there is a winner, and there's a race out there.
There is indeed. Thanks, Brian. Laurie, your one thought. What do you hope people remember tonight?
So, especially for some of our younger audience members, our Hill staffers and the like, our ability to lead in these critically important innovation races, these technological races, is not inevitable. The technology you enjoy today that seems almost as if it kind of dropped down from the heavens, like who could imagine a time in which you didn't have a cell phone? It was never inevitable that those technologies would exist. It was the byproduct of, decades, centuries of very intensive R&D activity that in this country has been beautifully incentivized, sustained through a strong patent system. Our ability to maintain those leadership positions is very tenuous and very fragile. And there are very aggressive competitors in different parts of the world that are laser focused on supplanting us as the world's inventors, leaders in those technology races. So losing sight of the importance of the patent system is, it is our first position to lose, and it can easily be lost if we fail to grasp the importance of patents.
Great, thank you. I'm going to give you just my last very quick final thought. Earlier today, I think it was Brian Pomper said, and correctly so, that when Phyllis Schlafly was going around and talking about the patent system and advocating on behalf of the patent system, she was like, why do we want to do it like the rest of the world? We have a gold-plated patent system. We need to do it right. We need to do it better because we are better already. Well, as Brian was saying that, I thought to myself, how many in this room would like us to go and have the patent system that the Germans have, or that they have in Brazil, or that they have in Colombia, or that they have in the Netherlands? The rest of the world is doing it better than we are, and that is embarrassing. And we can do better, we should do better, we must do better. And whatever you can do, no matter how small it is, come up with an idea and advocate. And we went 24, not 25 minutes, so you get an extra minute, Ed. Thank you very much, everyone.
Perfect. Thank you, Gene. Thank you, Brian, Hank, Hans, Laurie. I'll never live it down. We're going to take a few minutes to have dinner, and then we'll have our flag side chat in just a few moments. So enjoy dinner, and thank you for being here. Okay, everyone, if I can have your attention. If you're on that side, you're going to be a little disadvantaged. You don't see us as well, but this is what we call a flag side chat. There's no fire. So thank you, first of all, Congressman Posey, for being with us. And hope everybody can hear me. If you can't hear me, if you need to adjust your seat, feel free to do so. All right. Now, before we started, I had a chance to visit with the Congressman Posey. We welcome you and thank you for your time, for being with us, for your leadership. And we were talking, and you said a couple times, you used to say you'd never run for Congress. Never want to come back to Washington, D.C., where you'd lived as a young boy for a couple of years. And here you are. And I've had a chance to see some of your staff. And let me say, first of all, whatever a congressman is, his interns are a good judge of his character. Brendan and Kate outside are phenomenal interns. So thank you for bringing your interns with you. Yeah, give them a round of applause. Congressman Posey represents the 8th Congressional District in Florida, Florida's Space Coast, since 2008. He was elected in 2008 and has worked on the patent issues a number of times. Before being elected to Congress, he served 8 years in the Florida Senate, 8 years in the Florida House, and even on the city council in his hometown. I don't know, Jim Edwards wrote this, Mr. Posey is one of the most interesting men in America. Yeah, that's like a commercial, not a Bud Light commercial, but like the other one of the other ones. Anyway, he worked on the Apollo program. I heard him talking about the Apollo program and America's space work. He worked at Kennedy Space Center. He became an entrepreneur, started a real estate firm, and is an award-winning stock car racer. So I think we got to start with that, if you don't mind, before I get to anything else. What exactly does that mean?
Well, I'm just a gearhead at heart, an old southern redneck that likes racing cars, and most fun you can have with your clothes on.
The most fun you can have with your clothes on is what he said, Bill. Just wanted to repeat that because Bill looked stunned, Bill right here. He married his high school sweetheart, speaking of stock car racing, Katie, for over 55 years now, and he's been 40 years in public office. Now listen, this is really good. Former Congressman Ron Paul, what did I say, 40? What did I say, 4? Honestly, what's wrong with me?
You did good.
What's wrong with me?
You're doing good.
Hank is my best friend, and I call him Hank. Congressman Ron Paul, not Rand Paul, he's a senator, Ron Paul. See, Jim, I got that. He said this, Bill Posey is one of the few people in Washington for the right reason.
Yes.
That's pretty nice.
Yes.
That's pretty high praise. All right, so Congressman Posey serves on the Financial Services Committee, on the Science, Space, and Technology Committee, and he has used every opportunity he can to advance the America First vision through his assignments anywhere he can do so. Congressman, some of the biggest changes, we heard them today in our panels, have come through in the last 11 or 12 years, and in particular with the America Invents Act. You voted against that, and what's the deal? What did you see back then? Yeah, and what's going on?
Well, I didn't even know Tom Massey then.
So you weren't that smart yet.
I wasn't that smart yet. It was the first bill that came to the floor when we took over the majority. Now, in my legislative days, the Democrats, the first bill during session, would designate key pie as official state pie.
Right.
We would do an ethics reform, say members can't take money from lobbyists when you're in session. And I expected that we would do the same thing up here. But here we got this bill, and coming from the state legislature, it was a lot easier to read bills than it is here because they highlighted and marked them. But I kind of tried to get through this thing, and it sounded to me like they were going to take a right away from a guy who invented something and give it to somebody who didn't invent it. And so I actually went and spoke to the sponsor of the bill and spoke to the speaker, and they said, well, we have problems getting stuff done, there's time restraints, and this is going to make everything better. And I said, yeah, but I asked my chief of staff, Stuart Burns, he's here tonight. Stuart, probably the most experienced chief, one of the most experienced chiefs on the Hill. I said, Stuart, we got about 900,000 people in our districts. Never have even one of them mentioned the necessity to reform our patent laws to me. Never, ever, ever, never. I said, you were chief for Dave Weldon, you've been in so long. Has anybody ever mentioned that to you? And he said, no, sir, nobody's ever mentioned it to me. So, fundamentally, it didn't seem like a good idea to me. And, freshman, I hadn't been in trouble enough times for bucking leadership yet, So I, said, I'm not voting for this crap, So there you go.
There you go. What it sounds like, yeah, clap for that. That's a good one to clap for. Thank you. But it also sounds like, that's a good old-fashioned legislator listening to what is happening. But you maybe because of your background on the space work, you've consistently understood patents and invention and innovation. Where'd that come from? Is that part of your?
Well, I'm a realtor by profession.
Okay.
Nothing is dearer to me than property rights.
I see.
And I believe a patent is a property right. The judge mentioned that earlier tonight when she spoke.
Yep.
And I just lighted up when I heard you say that. I think they should be treated as such. Just, pretty simple.
Last year, there was the effort, Senator Pat Leahy decided his PTAB Reform Act was so good and so important, and you led the fight to keep it out of the NDAA and the omnibus bill and everywhere they tried to do. First of all, thank you for doing that. We appreciate it very, very much. And what did you see? Yeah, that's worth clapping for again. I shouldn't have to cue you guys. Come on, Bill. What's going on there, and what did you see? I mean, again, now you're up here a while. You sort of know what they're doing. What was going on here?
Well, actually, I'd like to take all the credit for that.
Perfect.
But it would be a lie.
Okay.
Your policy advisor, Jim Edwards, happened to drop by the office and tip us off on what was going on.
Really?
And so we had 3 patriots, right away, Thomas Massey, and 3 others. We got this letter, and we sent it to Leahy and said, hey, this doesn't belong in the NDAA, it doesn't belong in the omnibus. And obviously, he was getting a big going-away president. That happens a lot over in the Senate.
Yeah.
But you had people that were in a position to do that. And thank you for this organization for supporting that. And it was you guys being alert, and my action and my staff jumping into action with the support of some other real patriots. We have a few in Congress, and it did the trick.
Wow. Everything about that was great except Jim Edwards. He's going to try to, strut around the office and things now. It's hard to handle.
Well, he deserves a lot of credit for
the
that.
Georgia Bulldog thing is already too much. All right. Today we've talked a lot about patent infringement. Okay, Gene Quinn, he's got away with words. He calls it efficient infringement, and he says it's the cold-hearted business calculation whereby businesses decide it will be cheaper to use patented technology without paying than to license it and pay a fair royalty to the patent owner. My next sentence is, what's your perspective on this form of theft? But you're in Congress, so you see a lot of theft, and see Massey like that. See Massey, I heard him laugh. But this form of theft, again, back to property rights, and what we're seeing, it's easy. You'll see the evening news. People will go, "Oh, China's stealing our patents." Well, you don't have to go to China. Just go to Silicon Valley. They're stealing our patents. Or go look around, and they're stealing. How do you come at that? Where are we in terms of getting your fellow members of Congress to see it?
Well, it's a matter of convincing them that it is theft.
Right.
And you have to know that you have maybe an equal or larger pressure coming from the other side,
Right.
saying that it's not theft. You have to remember, somebody had the horsepower to make the original bill the #1 priority of the Republican Party.
Right.
Now, there's not very many organizations around here with that kind of horsepower. And so you know that if you want to change this, like the PTAB board, I think a lot of your life could be a lot simplified if we could make some tweaks there. If we couldn't abolish them, make some tweaks there, and some presumptions. And if Judge mentioned, there's also a lot of problems with the APA. Everybody just about that walks in my office that's in business, not just inventors and investors, but the general public, almost every profession or every trade comes in and says, they're trying to kill me. They're trying to kill me. Speaking about the federal government. Right. And usually they're not talking about laws that we passed, although we passed some pretty sad legislation that affects the public. They're talking about rules that the unelected, unaccountable, unrecallable bureaucrats make. If you're hauled into federal court, the chances are 10,000 to 1 that it's going to be a rule that an unelected bureaucrat wrote, not something that we actually passed. And so that's a big part of the problem. That's one of the reasons I ran for the state legislature, was to form the APA there. It took 8 years to do that. It's a great story of how that happened. And that's my attempt to do that here. And so far, we're still on the starting line, 12 years later, on the starting line. They don't want to do it. And so the agencies have been able to do whatever they want to do without any accountability for doing it, and they take full advantage of it.
maybe the most important question tonight is, how fast have you ever been able to go on a stock car track and then on a regular highway, like out on a highway, like you're down in like the Everglades and you got the all clear, there's no gators and a open road. What do you got? Yeah.
Yeah, I'm going to have to plead the fifth.
Really?
Yeah.
Really?
Yeah. Well, it would get broadcast to all the youth in my district. And I mean, I'd almost like to boast about it, but
I thought we had them there. We could have. All right. Okay. Well, we'll come back to that. I'll come back to that question. Okay. Sorry. All right. This is a hard one for me. I'll be honest with you. Patent issues are more bipartisan. It's hard for me to think about the other side right now, but they say that they are bipartisan. In other words, there's some Democrats that actually really want to do this. Opposition to the America Invents Act that united you on this one, where is the where does this fall on the party line thing? And earlier the judge, did you notice the judge was fired up? Didn't you notice that? She was pretty hot. I mean, I wouldn't want to. I'm glad she's not on the bench, so we'd have to face her. She was saying you got to fix this. And she said people got to understand what's happening. They don't seem to understand. How does this one fit into maybe getting people to look past the partisan issues and actually fix it? Any optimism?
Man, I don't want to get too partisan here tonight, but there's a big difference in how the Republicans vote and how the Democrats vote. The Democrats, 99% of them vote how the hell they're told.
Right.
We have about 50% of the yes sir caucus, and the others are pretty much like Thomas Massey. I mean, who knows what's going to happen?
Well said. Well said.
You're going to have to convince them that you're damn sure right, or they're not going to support you.
Right. So you're not optimistic.
No, I don't want to be pessimistic.
Well, I didn't say that.
A lot of that is up to you guys.
Right.
How well you work it. I mean, the other side had the strength to pass it.
Right.
Now, you'll probably never succeed in repealing it. I don't think that's a realistic expectation. But if you can do something about the board, for example, in a 1 or 2 year period, just as a starting point, your life could get a whole lot easier on how they're required to interpret. Does that sound right to you, Judge?
Exactly. All right.
I'm just making sure.
There have been some patent bills coming. Congressman Thomas Massey has his Restoring America's Leadership and Innovation Act. Congressman Donalds has his one to block the U.S. support for that TRIPS waiver. Senator Coons, Stronger Patents Act. Then there are the bad ones. We can go through them all that don't work. Look into the crystal ball. What's your best path forward on these? I know you started to say that, but what's the future looking like on these specific things? Is there room in the Republican caucus now because of the tight divisions that you can see, at least in the House, some progress? Where do you think it's headed?
I think it's going to be entirely up to you.
Man, I hate that. That's tough.
Yeah. It's going to be entirely up to you. I remember Stewart said, you be sure to tell this bank story tonight. So I'll tell you the bank story.
All right.
So, we know after 2008, any of you serve on any bank boards, the OCC has been putting banks out of business. And you might read about it in the paper and say, well, look, this bank has $950 million in assets and $250,000 in liabilities. How the hell they considered upside down? Say, well, the OCC goes in there and said, well, we don't think this customer should be able to pay this mortgage. So, well, the mortgage started out $950,000. It's $250 now. They'd never missed a payment. That doesn't make sense. They said, well, we think it does, so we're going to put it on non-accrual, which means you can't earn any interest from it until you paid off all the principal. And banks operate on what? So that's how you put them out of business. So, that's why you've seen such a declining number of banks, small banks. They'll talk to your banker about it. He'll give you an earful. So I had a banker from Jacksonville come in and brought all his board members in with him. He said, hey, the bank has just been, they're putting me out of business. They're doing this. I'm a 5th generation banker in Jacksonville. My father, my grandfather, blah, 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 blah. And he said they'd be rolling over in their graves if they saw what the government was doing now. I said, well, I don't think that's why they'd roll over in their graves. Because if they were still alive, the government wouldn't be doing this. See, I believe your father, grandfather had larger anatomical parts than you. And their generation wouldn't put up with this kind of stuff, you know? And instead, what you've chosen to do, like so many others, is stick your thumb in your mouth, crawl under the table in the fetal position, and hope to be the last sheep eaten. Now, I'm here to tell you, I'm here to tell you, you may not be the last sheep eaten, but you will get eaten if you don't do something about the government intrusion into your livelihoods. I absolutely promise you. I could give you a lot of examples about that. But just, the fact that you're here now, the fact that you've been working it like you have been working it, tells me that you're not going to crawl under the table and hope to be the last sheep eaten. So congratulations and thank you.
Well, the anatomical thing was the thumb. You said the thumb. That's why I wasn't keeping up. I was stunned back then. Bill, we'll talk later. All right. So you're actually pretty hot too. You're in a bad mood also now. You and the judge. You're really. I mean, we're in trouble. Are we in trouble?
Yeah, I think you're in trouble.
Me or everybody?
Everybody in the room. If
Really?
you don't do anything, if you stay under the table,
When you said earlier they passed it before, somebody got it all the way to the number one. I thought you were going to say, by the way, Pelosi's number one the last time was like gut elections, right? Remember? Hers, they didn't mess around. And remember, Bill Clinton's first bill he wanted was motor voter to try to change the voting. And your point back to this is that somebody had the horsepower to make that the number one priority of the Republican leadership. Is that still true?
Well, we have a different leader now.
Well, I understand that, but I mean...
we have a different leader now. And again, so much of that depends on you. Could they pass that lock, stock, and barrel again? I don't know. Could you repeal it lock, stock, and barrel? As I said, I don't think you could. I think that's too big of a bite, too big of a lift to do. But I think you can change significantly, dealing with the board, how they're required to interpret the law, since they usually... side with the thieves. and you can mandate these certain considerations, or, like a mandatory sentence. You shall interpret it like this, at this scope, and on this way to do it. I think there's a great chance that you could pull that off.
Okay. All right, Congressman Posey, thank you for everything you do. Thank you for being such a fighter for property rights and for our side on this, and being, I'd say, are really smart about it, savvy about it, for people that believe in you, and we're grateful. So thank you for being here, and more importantly, thank you for bringing a couple interns to help out. That was huge. So thank you. Thanks very much, Congressman Posey. Massey's asked for rebuttal time, but I've denied it. Denied, Massey. The chair moves on. Let's see, John Schlafly and Congressman Posey are coming back, and Judge O'Malley, I think we're coming back. We're doing awards. Is that right, Jim? Tell me I'm on the right schedule. Am I right? Okay, here we go. And Jim, you should come up too, because you did everything according to Congressman Posey. You're the one that did it all. So in 2020, we were very pleased. We created the Phyllis Schlafly Friend of American Invention Award. And Congressman Byron Donald's a past recipient, PTO Deputy Director Laura Peter, also a previous recipient. Phyllis's example, and it was so nice of the judge to speak of that so well and with such familiarity. We work with allies in all the parties. Sometimes it's hard to do, but in both parties. And we recognize the pro-patent efforts. And especially, all kidding aside, because it feels really a tough time with some of the other across the aisle, but Senator Coons has been discussion on this issue extraordinary. Former PTO director David Kapos. Is David here, by the way? Is he here tonight? He's been excellent, and what a great friend. So we thank them, and we work closely with them on those issues. Eagle Forum Educational Legal Defense Fund recognizes those men and women in office and out of office who are working to strengthen our U.S. patent system. The recipient of this award has sought to advance the exclusive right of inventors to their inventions for their entire patent term. Recipients have demonstrated leadership by advocating for and working for reliable, enforceable patents. They stand up for inventors' freedom to exercise patent exclusivity and to reap the fruits of their inventive labor. Recipients reflect the same devotion to invention and to inventors that Phyllis Schlafly did as a leader in the conservative movement and as a member of the Commission on the Bicentennial of the Constitution. I feel like, John, we didn't mention tonight, Phyllis, her father received a patent in what year, John? What year? Do you remember what it was? 1947 or 48, Phyllis's father received a patent for an engine, and she related to the process, the effort it took for him to get that patent. He actually didn't benefit from it, didn't make money off it, but had such pride in that. And in the book that Judge O'Malley and some of you took, the actual copy of the patent drawings and all is in the book. So she believed so strongly in that. So, Congressman Posey, we're pleased to recognize two people, and Judge O'Malley also, and Congressman Bill Posey. Congressman, you've stood up and been a true fighter to secure patents as private property against theft, and also Judge O'Malley, a distinguished jurist whose service on the bench has served to improve patent jurisprudence. We're very grateful, and we're pleased. John's going to come up, take off his name tag, and help us deliver these awards. And so please, and then each of them will make a few comments for us. So, John, do you want to make a comment? No. You know? Should I open these? Yes, you should. No? Well, we'll do Congressman Bill Posey, and we thank you so much for everything you've done, and we're so pleased to honor you with this award. So, Congressman. Everybody. John, come on. Hold on, Ron's here. John.
He's good at this.
That's right. He's a pro. John, come on. Oh, no, that one's not done yet. Do it right in a minute. Just get in here, John. There we go. There we go. This is just John. Now you hold that one. You got it? All right. Now you get your. Well, there's. Oh, John. Judge O'Malley, thank you, and especially thank you for in preparing for this. It was really great to have you looking at Phyllis's works and speak about it so much. So thank you very much.
I'll go first. I'm not going to talk about patent law. I want to say a few words as a mother and a daughter, or a mother and a child. I was like Phyllis Schlafly. I was very proud of the fact that both of my parents had patents. Sadly, my mother's patent, she was working for the government at the time, and they didn't even put her name on it. Because back then, women's names did not go on patents. So all these years, I have understood that my parents, my dad was a chemical engineer, my mom was a chemist, that they were so proud of what they had done. And when I started reading about Phyllis Schlafly, it was almost shocking that that was part of what motivated her. And I don't know if that's what motivated me in terms of my feeling about the patent system, but it must have. And I also want to say that to you and your whole family, it's amazing how much you have honored her legacy and how much you got involved with everything she was doing. And my children don't want anything to do with what I do. They say there's way too much paper around the house. They don't want anything to do with being a lawyer. But I think deep down they're really proud of me anyway. But it's beautiful to see what you have done with your mother's legacy.
Thank you, Judge.
Well, as a great admirer of Phyllis Schlafly and with deep and abiding respect, that makes this very, very meaningful to me, and I'm just honored to be part of her legacies. Thank you very much. Okay.
Thank you. John, say a few words.
Well, I'm so happy to be part of this event, and thank you all for coming. And I think it's been a big success. In fact, I think this 7th annual event is the best one we've had, Ed.
Wow, okay, well, that's good. I like that. That's good. All right, John. Thank you, John Schlafly. And you heard mentioned, thank you. You can all go to your seats now if you'd like. And I've got about a 45-minute talk I want to deliver now about a few things. I had chickens once, and I wanted to not have to move the, oh, no, that's Massey, sorry. If you haven't seen the book that we've been referring to, Judge O'Malley and I are having this back and forth. Phyllis Schlafly speaks. There's some volumes. What volume is it? 4? Volume 4 on patents. She wrote on patents dozens and dozens and dozens of times. And chapter 3 is my favorite. It was a speech she gave in the mid-1980s at the Daughters of the American Revolution, where she catalogs how, and it made the women's libbers crazy, she catalogs how women at that moment in the 80s had it better than any women ever because of all the inventions that Americans had come, a dishwasher, washing machine, all these things. And she took great glee in giving that speech, but underlying it was her description of how the American economy was second to none in the world, in large part precisely because of the patent protection. I want to say thank you again to Jim Edwards. All kidding aside, Jim, thank you for all you do to help us on these issues and help us and Phyllis Schlafly and her legacy. So thank you for everything, Jim Edwards. Ryan Height was in the back, and our team, Ron is our great photographer for decades with Phyllis, and our videographers. Thanks, guys, for everything. Thank you, Ron. Again, our sponsors, Bio, Hank, Deliver, Innovation Alliance, InterDigital, Acacia Research Group. We are so grateful for everything that they do to make this possible. Every year, see, on our team, John, I know you're a nice judge, John is kind of like the busybody who says things like, how much money have we brought in to cover the cost of this event? And Jim always says, here's the sponsors, John, and here's how it worked out, and it always does. And so we're very grateful for that. And I'll finish by saying, and thanks, Gene, thank you for hosting, for helping us. You do awesome work at the Watchdog and also with us. We're grateful. But I'll finish by echoing Congressman Posey's point of view, his encouragement. It's on us to make this work. It's on us to change the narrative. It's on us to make it clear the American dream isn't sort of something that happens because it's really neat. It happens because it's possible for men and women to make things for themselves and make it profitable, make the system work. And so we got a lot of work to do. We got a lot of forces on the other side that somehow put the bills number one for our side that don't look like number one for America, but that's a different problem, and we need to do it. So every year we're here, but in between we're out there and over there and out in the community. So we'll look forward to that. And thank you all for being here again. We'll look forward to seeing you very soon, and God bless you. Thank you.